So what is special immigrant juvenile status? So this is a law that was created in the 90s, and the purpose of the law was originally for children in foster care. The foster care agencies were realizing that they had undocumented children in their care, and they were aging out and weren't able to provide them with any permanency or stability for them in the future. So what the law did was it aimed to protect neglected, abused, or abandoned undocumented children. It's kind of a unique area of immigration law because it intersects with family law, and before you can actually go to immigration authorities to ask for the SIJ petition and then the green card, you actually have to go to a state court to request an order from the judge that makes certain findings, which we will go in depth about today. In New York, the state court that we most commonly use is the family court, and most of this presentation will be focused completely on New York law for today. When a child applies for special immigrant juvenile status, they're given their if they're approved, they're given their green card. So it's a gateway for them to be able to get federal financial aid, medical benefits, they'll be able to work in the United States, get their Social Security. Some important considerations that some people don't know when they are doing this is that if a child is granted special immigrant juvenile status, they can never apply for either of their parents. Like, as I mentioned earlier, was the purpose of this law originally was for foster care children, and you had to show abuse or abandonment to both parents, and they put that provision to make sure that the system wouldn't be taken advantage of. The youth can also not be married while the case is pending, and if you're doing this case while they're in foster care, they cannot sign out until the case is finished. So even if they turn 18 and their green card is pending, they need to stay in foster care until they actually get their green card. Okay, if not, they become ineligible, and we'll talk a little bit why in the next couple slides. So who qualifies? So this is the eligibility requirements under the statute. You have to be a child, which is defined as unmarried and under 21. And this is, you have to be under 21 at the time that you file. So if you file, let's say, 20 and 364 days, it's okay as long as that application was in before the 21st birthday. It's okay if it's pending afterwards. You have to be dependent or committed to the custody of state agency or individual, and we'll go in through what those definitions are next. And then you also, there has to be a finding that reunification with one or both parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law. I mentioned that when the law was created, it was originally abuse, abandonment, or neglect by both parents. The TVPRA had expanded the law and changed it to one or both parents, and we'll go in through the expansion in a little bit. It also has to be found that it's not in the child's best interest to be returned to their home country. So these are your sources. This is where you would go to find the statute. The statutory authority in the INA was amended by the TVPRA, and those amendments are in the statute when you look at it. But I will note that in the regs, there actually have not been updated. So when you look at the regs, a lot of the TVPRA amendments are not there at all. So what did the TVPRA do in 2008? It expanded SIJ in a significant way. It changed, as I mentioned, that language from having to be both parents to one or both parents. USCIS has stated that they will follow the plain language and the New York state law clearly, and we're going to go in depth into what exactly one or both parents means in a few minutes. Also, it took out the language that said that you had to be eligible for long-term foster care. So the child no longer has to be in foster care. They just need to be declared dependent on the court or placed in the custody. This is one of the areas that the regs still say long-term foster care and sometimes confuses people when they're looking at the regulations. It also added that besides abuse, neglect, or abandonment, there could be a similar basis under state law. And that Maureen will talk a little bit about what in New York that exactly means. It extended eligibility cases to be filed by age 21. Before the TVPRA was unclear on whether or not a child who had turned 21 through the process would continue to qualify. The TVPRA made that clear and said as long as it's filed before the 21st birthday, the child will still be eligible. And it also modified the consent procedure for youth in federal custody. This is only for child who is still in custody at the time that you're doing the application, but this doesn't apply if you have a case for a child who is in OR custody is then released into removal proceedings. You don't have to worry about that consent requirement. So let's just go through some definitions before we get into kind of like the nitty-gritty of family law and what exactly to do when you're in family court. So under federal law, a juvenile court is a court that makes a determination about the care and custody of juveniles. In New York, like I mentioned before, we usually use the family court, but people have used the Supreme Court and have also used the surrogate court and have even used the criminal court. Dependent means that the court has to have taken jurisdiction over the child and then committed to in the custody of state or individual appointed by state or juvenile court. In New York, the courts have said that that includes foster care, custody, guardianship proceedings, PINS proceedings, delinquency, and paternity. Best interest, so that's kind of like for the fifth prong. This is very case specific and really depends on your facts. There's really great Second Department appellate law, which we have provided you, that kind of talks about the different factors that go into this best interest analysis. As we've mentioned a few times, the child has to apply before turning 21, and the specific consent only refers to someone who's in federal custody. So if you're representing someone who was in OR custody and released to a sponsor, you don't have to worry about that consent requirement.
And just to be clear, the filed before 21, thank you. There's always a lot of confusion about this, so it's really important to, the application actually has to be received by USCIS prior to the child turning 21. And the reason we emphasize that is that there are unfortunately cases all the time where people are using filing rules from other parts of the law and thinking that perhaps putting it in the mail, having proof of mailing will count as filing, but it does not. And it's really probably the most awful thing when you're that close to obtaining relief for a child to find out that in fact you've missed that deadline.
So these are some examples on state court proceedings and family court proceedings in New York that we have been able to get these orders to then go to immigration. I think the most classic common example is the foster care Article 10, but it can also be done in adoptions, PINS, custody, guardianship, juvenile delinquency. And then these are some of the published decisions which we thought would be really important for you guys to have while you're doing one of these cases. I believe they handed out the cases to you, and we've also handed out some case summaries so that you can easily identify what cases will be helpful for you.